Hello, I'm Andrew Flushy. Driving on suspended is a very serious offense that I think a lot of people sort of dismiss and disregard as being that serious. It's what it says, it's under the code section 462-301, and it says that any person whose license is suspended can't operate a motor vehicle in the Commonwealth of Virginia. That's a thumbnail summary of the statute. It's rather long. But basically what happens to a lot of people is if you forget to pay a court fine, or if a court suspends you for another violation, and then you later on drive a vehicle while you're suspended, you can be convicted of this Class 1 misdemeanor. The problem that I see a lot and hear from a lot of people is that, oh, if I get my license reinstated and it's fixed before the court date, they'll just drop the charges. The bad news is that that's not normally the case. In some courts, they will do that, on your first offense perhaps, but not in all courts, and most likely not when it's not your first offense. So if you've had a prior offense of driving on suspended, and this is your second or your subsequent more than that, then you're not looking at having the charge just dropped if you get your license fixed. And again, in most courts, they won't normally even do that. They might reduce the charge to something a little bit lesser, like not having a valid license or not having a license in your possession, which is only a $10 fine. But in a lot of courts, they won't just simply dismiss it by having your license fixed. It's one of those kind of regulatory offenses that it's not endangering anyone, so that's one reason people don't take it too seriously, because nobody's in danger, and that's not what the Commonwealth would argue, but it is the law. The law says that you can't drive while you're suspended, and it is a misdemeanor. It's on the same level of misdemeanor as a DUI. It's not stigmatized like a DUI, but it's the same level of offense. The important thing that people need to remember is that if you've had two prior driving on suspended offenses that you've been convicted of, your third or subsequent offense could entail jail time. And more importantly, it could trigger a 10-day mandatory minimum jail sentence, where you would have to serve 10 days in jail if you're convicted of a third. One really important thing for your attorney to do in a case where you have priors is to pull each prior, get a certified copy of each one, and analyze it and see if there's any errors, any helpful arguments for your defense that could make that prior not count. And even if it's only your second offense, even if there's just one prior, knocking out that one prior could mean the difference between a day or two in jail and no jail. And if it's your third offense, if we could knock out both priors, then that would mean you wouldn't have any jail time instead of 10 days mandatory minimum. Now, every case is certainly different, and it doesn't always produce something fruitful for our defense, but it's something that we should always check into, is getting those priors. So in sum, just remember that driving on suspended is serious. Fixing your license is important, but it's not going to necessarily make the charge go away. And if you have priors, we definitely need to get a copy of all those priors so we can check them to see if we can use them in our defense.